Susan, we're delighted to have you here at UCL for this workshop on private authority and global health governance, organised by the Institute of Global Governance and the Institute of Global Health. You've written extensively on private power and global governance, in particular in the area of health and intellectual property policy. Are there any lessons that advocates for stronger global regulation of harmful products, such as tobacco and alcohol, could draw from the experience of public health advocates in the area of intellectual property policy?
Yeah, I think what worked best for the health advocates in access to medicines was the framing of the issue as a life and death issue, framing it as a public health issue, not some technical intellectual property issue that nobody really fully understands, not even a trade issue that's the province of trade lawyers. But people are going to die if they can't get this medicine, and this is a policy that stands between people and the things that could save their lives. And so I think that was a really strong framing for the issue of public health and access to medicines. I think in the area of tobacco, which is very interesting, versus pharmaceutical companies do a lot of nasty stuff, but they also provide drugs that save people's lives. I mean, that was the whole point. People wanted to get access to them because some do have a good effect. And so with tobacco, that product does nothing but kill people. And there's a lot of controversy right now over the Trans-Pacific Partnership Agreement and also TTIP with Europe, another trade agreement between the US and Europe. And they are talking about implementing or adopting investor-state dispute settlement procedures where a private company could sue a state for its regulations. And a number of tobacco companies are going after Australia right now under the US-Australia Free Trade Agreement because they do have that provision. They're going after them for their plain packaging of cigarettes because public health regulations are trying to discourage the smoking of cigarettes. So if the packages don't look sexy and appealing and exciting or whatever, they're hoping people will not buy them. And so the cigarette companies are arguing that their trademarks are being violated because they're not allowed to put their signature, symbols or whatever on the packages. But just in the last few days, I believe France is on the verge, I heard, of adopting plain white packaging for its cigarettes and maybe even outlawing e-cigarettes. They're taking steps in that direction. So I think, in a way, framing it as a life and death issue is helpful. I find it actually kind of amusing. During the anti-counterfeiting trade agreement negotiations, there was a representative from Philip Morris testifying before U.S. Congress saying he was very concerned about his customers getting a hold of counterfeit cigarettes. And I was reading this thinking, okay, you don't want them to die from fake cigarettes, you want them to die from the real cigarettes that are your brand name. It was just absurd. But cigarettes don't have any positive benefits, whereas pharmaceutical drugs do. I think in the area of cigarettes, I think it's important that the World Health Organization adopted the treaty on tobacco. And also in the World Health Assembly, a number of years ago, I think it was 1999, they adopted a resolution that no intellectual property laws should stand in the way of states being able to provide their citizens with public health necessities. And that language was taken directly from the World Health Assembly and brought over into the World Trade Organization, and that became the Doha Declaration on TRIPS and public health, just emphasizing that this social good should outweigh private property rights in that event. So I think there's a moment now with the concern over e-cigarettes, with the treaty from the WHO, from the fact that it's really hard to make an argument that there's a positive benefit of cigarettes, that might be ripe for more regulation. I mean, I think that tobacco companies, they know for a fact that they're running out of markets, and so they're pushing it on youth and they're pushing it in Asian markets, and because the number of consumers is dropping so dramatically. And so we're seeing huge spikes in heart disease and lung cancer. All the smoking-related ailments are now spreading throughout Asia in particular as people take up cigarettes because they're just looking for new markets for their nasty products.
So going a bit deeper, I mean, your research really reveals the complexity of global public policy making today. In particular, this shift from multilateralism to what you term going granular. Could you perhaps elaborate on what you mean by this term and how it's transforming traditional modes of interstate multilateral governance?
Yeah, what's really interesting is a very dynamic time right now, I think, in global governance, in that the interstate multilateral arena is not where most of the action is. In fact, very little of the action is there anymore. Part of the reason for that, I believe, is that there's a power shift, and the institutions, the multilateral institutions that we set up after Bretton Woods, no longer reflect the post-World War II power dynamics. There's been, with the emerging countries like China and Indonesia, India, Brazil, South Africa, it's a different world. And those countries have different preferences than the preferences of the United States. So I feel like the United States firms that own intellectual property are trying to make a big grab, like dinosaurs before the meteor finally crashes down, because they know that their business model is in jeopardy. So they're trying to lock in these monopoly advantages. And they know they can't get it in a multilateral setting. They know Brazil, China, India, none of them are going to agree to what the U.S. is asking for. And so what they're doing is negotiating vertically instead of horizontally. They're going vertically, and parties tend to negotiate vertically, meaning avoiding the multilateral arena and going deeper down when they have interests that are at odds with the interests of most other states, and they know they can't get it multilaterally. So what they'll do is they'll form what they call or consider like-minded groups, or enroll weak parties that they think will go along with it for other reasons, and get agreements that they could never achieve in a multilateral setting. So we've seen this in a number of examples. One is the Trans-Pacific Partnership negotiations, the regional agreements like NAFTA, CAFTA, acronym hell, right? Central American Free Trade Agreement of the United States, the European Economic Partnership Agreements, where you can use your advantages of your large market, or the promise of investment, or the threat of discriminating against others' goods as a way to get a country to adopt regulations that favor you. And so that vertical shift allows the U.S. to maximize an advantage that you don't get in a one state, one vote kind of multilateral setting like the World Trade Organization or a consensus voting area. What's very interesting to me is, especially in the case of the Trans-Pacific Partnership negotiations, that the countries that the U.S. is most interested in, the ones they are most concerned about, none of them are at the table. There's no China, no Brazil, no India, no South Africa. Well, there's Morocco. But the idea, what the U.S. is trying to do, because they can't get what they want multilaterally, and they want much, much stronger, higher standards of intellectual property protection. So what they're trying to do is enroll enough like-minded or very much weaker states, or ones that are already yoked to high standards through bilateral agreements. They're trying to, if they can enroll enough countries in that kind of agreement that the U.S. desires in terms of intellectual property, they are hoping that China, India, South Africa, Indonesia, Thailand, Brazil will really have no option but to go along. And so it's a way of getting what they want, like making an end run around the multilateral arena to lock in undesired changes that over time these other countries might feel compelled to adopt. That's the strategy, I know, of the firms in the U.S. government in adopting these kind of agreements. They're plurilateral, with the plurality of groups, not multilateral. They could be bilateral. They could be, they're also sometimes unilateral, when we name and shame countries and threaten them, even if they're not doing anything that's in violation of international law or World Trade Organization agreements. Their sin is simply they don't have policies that we favor. Even though they are, India is a perfect example. We keep hammering India for every reason under the sun, even though all the laws that they've adopted to try and promote access to medicines and to promote generic competition in the pharmaceutical area, they're all perfectly permissible under their international law obligations with the World Trade Organization. But the U.S. is not satisfied and will not stop until India dismantles the flexibilities that it's adopted in order to increase access to medicines. And the U.S. is worried that other countries are going to copy India's law. Some already have. The Philippines has, that promote generic competition. and they're afraid there's going to be a domino effect, and that our pharmaceutical firms will lose out to generics.
So at the same time, you've written recently on how Brazil, China, and India are likely to write the next chapter in intellectual property policy. Do we see this already happening? And more broadly, what do you think will be the impact on regulation of private authority as these emerging powers, and especially China, increasingly flex their muscle?
Well, I don't expect, I mean, the situation is trending in a couple different directions, I think, in terms of these up-and-comers. You know, what kind of intellectual property policies are they going to favor? In some sectors, China is being even more hardcore than the United States. If you think about Huawei, which is one of their shining, state-owned companies. Well, they say it's private, but everyone's confused what extent it's really private, or whether it's state capitalism, or whatever you want to call the firm, or how much the military is involved. It's very debatable. But that company has been suing another Chinese company all over European markets. They become so litigious over their patents that they've learned the worst examples of the West and are adopting that strategies to beat each other to death in European markets. China has become the most litigious country in the world in terms of patent litigation against other Chinese domestically, which is a bit of a surprise. But their attitude, and I've been to China and interviewed a number of business people and people at the patent office, is we want to, we've seen what the U.S. does. They sit on that side of the table and they get all the royalties and licensing fees. We want to be on that side of the table now. And so they're really enforcing them in a lot of areas where they have some sectoral advantages. In sectors where they're weak, they're not really worried about enforcing it. So they're being much more selective about enforcement. They're really ramping up their judicial capability in intellectual property enforcement. But I think they're more being selective at the moment, and they are trying to get access to technology as cheaply as they can and make deals. They've made an interesting deal with GE's aviation patents, and they got a lot of technology from GE Aviation in exchange for GE being the partner for a Chinese aviation industry. So there's a big advantage to be the first one in the door with that. But one part of the deal was they had to transfer a lot of technology to Chinese partners. But I think in all these cases, we should not expect to see the same kind of policies that the U.S. has pursued. There'll be some that look the same, but one of the big differences between all those countries and the US and the EU, for that matter, is all of those countries are home to a significant population of what Paul Collier calls the bottom billion, people that live on less than $1 a day. And these countries all have to worry about social stability. And they don't have the luxury of forever ignoring the needs of the people at the bottom of the totem pole, and there are a lot of them in those countries. So in order to address those public policy needs and those social needs, I think their intellectual property policies are going to have to look different. But are they flexing their muscles? Yes, they are, starting with the insistence upon a development agenda in the World Intellectual Property Organization, which is actually what got US and Europe and Japan scurrying out of WIPO, World Intellectual Property Organization, and announcing the Anti-Counterfeiting Trade Agreement, a plurilateral move, announcing the Trans-Pacific Partnership Agreement, because there's stalemate in norm setting at WIPO around the development agenda. So yes, they are pushing back. They are asking sharp and informed questions at World Trade Organization about to what extent ACTA or TPP might undermine some of the multilateral agreements and what relationship they would have vis-a-vis the multilateral institutions, where they prefer that rule-based system to the power-based system. So it's a really interesting time. We're seeing power shifts, and we're also seeing a lot of strategic forum shifting, both horizontally across multilateral organizations, from WHO to WTO, back to WIPO, World Intellectual Property Organization. And then we're seeing a lot of vertical form shifting from multilateral, plurilateral, regional, bilateral, and even unilateral with the naming and shaming. So it's a very complicated dynamic.
So as you've highlighted, the role of the market in global health governance raises a host of questions around legitimacy, participation, accountability. In your view, how can and should global public law be developed to better or more effectively regulate private actors or hold them accountable for health outcomes?
Yeah, this whole move towards privatization to me is rather frightening because I think there's a lot less transparency. We see that with the Trans-Pacific Partnership negotiations, where in the United States, Congress people who are our representatives, they're not even allowed to see the text. The only reason we as citizens have seen any text is because of WikiLeaks. And so, I mean, that's troubling from a legitimacy and accountability standpoint. That's troubling. And I think that there's, in a way, like with the defeat of the anti-counterfeiting trade agreement in Europe and an open domestic process in the United States that killed 2 internet bills, the Stop Online Piracy Act and the Protect Intellectual Property Act. What I'm concerned about those victories for people that want to see a different system of intellectual property protection that is more balanced with the public interest included. What I'm afraid it's leading to is private actors going even deeper underground and much more private ordering. We can see that in the instances where internet service providers are now signing private contracts with content providers that leave the consumers out of that triangle. I think we're seeing a lot with the role of foundations in health governance with the Gates Foundation. For one example, at least Clinton Foundation buys generics. Gates Foundation won't. But at the same time, there's the patent pool in the UN, and James Love of Knowledge Ecology International has a very interesting proposition floating around, and that is to have a multilateral agreement that would be very much like the General Agreement on Trade and Services, but would be all a positive list where countries would only offer to list the things that they wanted to participate in, and the metrics would all be public interest or public good, like best practices for increasing access to medicine. And if you had some metrics like that, you said countries could pledge to be avatars of that approach towards promoting access to medicines or access to educational materials or digital media or germplasm or, books, drugs, and seeds, the things people need to live and need to grow. So I think that's a really interesting proposal. It's a creative one that would, instead of all the naming and shaming, would give states an opportunity to be better global citizens and better towards their constituencies. So depending on the day I get up, I'm either a really depressed idealist or I'm a really optimistic realist, depending which way the wind blows. But there are strands currently that point in both directions, and I'm not sure that I think we're a long way from any kind of stable equilibrium in this policy space, whether it's intellectual property policy or global public health, with the consensus. And I think we're going to continue to see this really dynamic, ever-evolving, vertical, horizontal shifting. And Peter Dreyhaus wrote once that negotiations are never really over. And I think that's a really important way to think about it, whether you're a scholar or an activist. Because you can't just go, woo-hoo, yay, Doha, declaration, we won. Because those guys are always out there pushing for more and more protection, more and more rights. And they have a lot of resources. I had a very disturbing encounter. I was doing a training for Pan American Health Organization on access to medicines, trade, and intellectual property. And there was a doctor there from Jamaica. And she told me her preference was always to prescribe generic drugs because her country's so poor. But she said increasingly patients are coming to her saying, oh, no, I want the Pfizer drug. Those generic drugs, I think they might be substandard or maybe they're counterfeit or unsafe. And brand name pharmaceutical firms have deliberately tried to create that confusion in consumers' minds, and they have a lot of resources to reach out to patient groups. And I find this alarming, and when you said I use that term going granular, it's that kind of ability to staple things in on the ground, even in people's minds, to confuse them and make them think that generics are dangerous or bad, that's very hard to combat. You know, people on the other side of these issues don't have the kind of resources that these folks have, partly because of the intellectual property policies they've been able to get, so they're making super profits, and they're putting them more and more into their advertising and their lobbying and advocacy efforts.